Honorable, to move on to another issue, and this one is about what is the suspension of the Chief Justice. We've had a couple of conversations on it where you are of the opinion that the president thus far has upheld the Constitution in everything he's done with the petitions that came to him. Now, this is FIDA speaking. This is such an act, if devoid of transparency. So they are talking about the suspension of the Chief Justice. Such an act, if devoid of transparency, due process, and public accountability, undermines public trust in the very institutions meant to uphold justice. FIDA Ghana, a staunch advocate for the rule of law and protection of vulnerable people, especially women, advises that the right of the Chief Justice must be respected and upheld at all times, and her office be treated with dignity that it deserves. And then they continue that it is disconcerting, the increasing spate of removal of individuals from strategic, constitutional, and institutional leadership, especially when such persons are women. Regrettable. These removals have become the norm whenever there's a change in government from the leadership of one party to another. It seems they are one of the institutions that are not happy, and they've expressed concern over the suspension of the Chief Justice.
Who signed the letter?
It's from FIDA, International Federation of Women Lawyers.
But who signed it?
It's not clear who signed it. It's a state donation.
I would have loved to see who signed it, because last week Saturday I was with Gloria.
Okay.
On the news file.
Okay.
And it came out that she's now the head of FIDA.
Oh, okay.
And Gloria is a former parliamentary candidate of the MPP.
I see.
She was the one who famously said on the set that it was President John Dramani Mahama who led the petition, defying all logic.
Yes.
That the petition had gone to 3, now I even think 4 different institutions. And she said, well, the petition was leaked by John Dramani Mahama. So I would like to see who signed the petition. But in any case, everybody agrees, including the Ghana Bar Association, to which we are all members, agree that John Dramani Mahama has ensured the integrity of the process, has shown fidelity to the law, has always been acting because he's keenly aware of his duty under the Constitution. He doesn't want to be accused of gross dereliction of duty. So he's done what the Constitution says he should do. It's why he's even extended beyond the Constitution, because the Constitution doesn't say that he should give the Chief Justice 10 days allowance for forwarding the petition to her to give a response. Well, he's done that. That should show that he is an impartial arbiter in this matter. Or if you want, a neutral arbiter in this matter, and a conveyor belt of sorts. Now, I'm surprised that FIDA is not raising this issue. The first occupant of an independent constitutional body that came under attack was in 2015, when another umbrella filed a petition for the removal of Loretta Lamte. She was the head of Siraj, remember?
Yes.
The petition was brought for her removal by another umbrella. Now, in 2018, another petition was brought for the removal of Charlotte Osei. The first petition by a headless group of people. The second petition by officers at the EEC. Charlotte Osei was a woman. I never heard FIDA complain. Or did you hear FIDA complain that there was an unnecessary attack on Charlotte Osei? And we had heard people say publicly that Charlotte Osei was an NDC member, and that she was a card-bearing member of the NDC, and that they were going to remove her if they won the elections. And they went ahead and removed her. And FIDA did not complain. Now, what is happening? Let's put that in perspective. Article 146 is the removal of justices of the Superior Court of Judicature and regional chairmen. It's a process provided by the Constitution for the removal, for holding judicial officers accountable, or persons occupying offices analogous to a judicial office, accountable for their rules in those offices. So, Loretta Lamte was subjected to Article 146 of the Constitution because the head of Shiraj enjoys terms and conditions conterminous with the justice of the Court of Appeal. Charlotte Osei was subjected to the treatment under Article 146 of the Constitution because the Electoral Commission enjoys terms and conditions conterminous with that of the Court of Appeal. And so, Article 146 has been invoked and used to suspend and remove from office occupants of certain constitutional bodies. Now, what is this whole farce? Let me try to summarize it briefly. So the Constitution in Article 146 has put in checks and balances, which in the ordinary layman's language will be constitutional restraining instruments for the exercise of the executive power of the president. And you see it littered all over the Article 146. Now, I earlier told you that Article 146 is for the removal of justices of the Superior Court of Judicature and regional chairmen, the head notes of Article 146. Now, so where a petition goes to the president for the removal of justice of the Superior Court of Judicature, the president will have to forward the petition to the Chief Justice for a determination of whether or not there is a prima facie, the petition raises a prima facie case or a tribal issue. It is the Chief Justice as head of the judiciary who determines that. So, Charlotte Osei and Lamte came under Article 146 because of the offices that they were holding that was analogous to the office being held by the Justice of the Superior Court of Judication. So it also came, the process came under the jurisdiction of the Chief Justice. Now, Article 146 of the Constitution takes into consideration the cardinal principle of natural justice, that when a petition involves the removal of a Chief Justice, mind you, a Chief Justice is a justice of the Superior Court of Judicature. And normally, petitions to remove justices of the Superior Court of Judicature must go to the Chief Justice to determine whether the prima facie case. But in this case, if the petition is against her, if the petition is for her removal from office, she cannot be a judge in her own cause. Do you see it?
Yes.
So the law then says, in respect of the Chief Justice, it is the President acting in consultation with the Council of State that determines whether the petition has raised prima facie issues. Now, so clearly, when you read Article 146, there is an institutional limitation on the exercise of power by the President. Mind you, Article 146.3 doesn't impose any institutional limitation. It doesn't say that the Chief Justice has to determine whether the petition has raised a prima facie case, acting together or in consultation or on the advice of the Judicial Council. It says the Chief Justice. But in Article 146.6, there's an institutional limitation. Why is that so? That is done there to protect the dignity and sanctity of the office of the Chief Justice. So that's a protection for the Chief Justice. The President has no power under Article 146.6 to determine the prima facie case, whether the petition raises a prima facie case alone. He must do it in consultation with the Council of State. Now, you calm down. When the petition when it is decided that the petition has raised a prima facie case, the Council of State must establish, to acting with the President in consultation with the President, or the President acting in consultation with the Council of State, must establish a committee. And that committee is a judicial, by the 1969 Constitution, is a judicial committee, a judicial tribunal. Now, when that tribunal is established or that committee is formed, the Council of State has to advise the President on the status of the Chief Justice. And the President must act in accordance and the line with the advice of the Council of State. So you see there's a procedural limitation on the exercise of the power of the President.
But I'd also suggest that when it comes to suspension, because of the use of the word, they said there's a may, it means the President has a discretion whether or not the Council of State advises it.
Now, so when you find in the Constitution or in an act detailing the procedure of how the suspension can occur, the may there can only be read to mean that the President can only exercise that discretion if the Council of State advises. So if the Council of State does not advise the President to suspend the Chief Justice, the President cannot. That's why the may is there.
Okay. So the may applies to the advice of the Council of State, not the President's discretion.
The may is a condition precedent.
Okay.
On the for the advice, for the President to act on the advice of the Council of State. So you must read the may. If you take the may standing alone, without reading it in conjunction with the action on the advice, you would think that the President, even without advice, may suspend the Chief Justice. And I'm saying that no, because the President is obligated under Article 14610A to act in accordance with the advice of the Chief Justice. If an advice comes that in accordance with the advice of the Council of State, if the advice comes that the President should suspend, he has to suspend. But if no advice comes, that's why the may is used. The President cannot suspend. That is why when the President suspends, the President can, at a subsequent date, remove the suspension. But that time, he doesn't have to rely on the Council of State. Now, you also find a provision in the Constitution, I think Article 146(8) or 9, which says that the President shall act in accordance with the decision arrived at by the committee established.
Yeah, the recommendations of a committee.
So again, it takes off the power of the President to act independently. Again, the power of the President has been circumscribed. And in my view, this circumscription is almost like a substantive limitation on the power of the President. So the President cannot ignore the advice or recommendation of the committee established under Article 146(6) of the Constitution. So when you read all together, you will come to one conclusion, that the checks and balances